It's really good to be here discussing licensure because, as most of you know, it's a relatively new thing in Colorado, and I think that that's why it's generated such a discussion and level of interest that would have you all here. We have heard a lot of questions and concerns over the years, and that's why we decided to have this licensure discussion, and we'd like to keep it fairly informal. We've invited hopefully the people that can answer any questions you have and help you learn the reason for regulation, the ways that the state regulates it, and how we as practitioners are engaged and integrated into the licensure process. So let me introduce the panel that we have here. To my right is Neil McLean, who's the ASLA Chapter Government Affairs Director. And Neil has been championing the advocacy of licensure and continuing education and CLARB and general regulation at both the national, the state, and the local level for the past couple of years. And quick promotion, too, will also be involved in ProGreen Expo in February, where we'll be doing a similar session to this with probably a larger audience. My name is Craig Coronado. I'm with Wank Associates. I'm a landscape architect. To my left is Jamie Ramos with Stanley Consultants, who's also a landscape architect, and he's a member of the Landscape Architecture Board at the state of Colorado. And I believe are you the chair of the board? Currently, yeah. Okay, good. Next to Jamie is Angie Kennard-Lynn, who's our program director. She's responsible for overseeing the Landscape Architecture Board for the State Division of Regulatory Agencies, which is what DORA stands for. And we've known Angie for a long time. She's come with us through the whole process of Sunrise, which was the mechanism that enabled the statute to be passed by the legislature. So she's intimately familiar with the profession of landscape architecture, and she works closely with the other professions, architects, engineers, land surveyors as well. Next to her is Christy Thomas. She's the board enforcement director. Okay. And so she can answer questions, and she'll have a short presentation on how they oversee the regulation and assure that it's effective at the state level. And then I think we all know Dean Pearson at the end of the table, a landscape architect with Architera Group. And Dean is also a member of the LA board and also a member involved with the CLARB liaison. What's your role on the board?
Yeah, I've been involved with CLARB for many years. Started out grading exams. I was chair of the Section E committee that wrote problems, the grading and drainage section. And now I'm on this new prototype committee that's working on reformatting the test. I'm sure you've all heard about that.
So the four folks from DORA and the board will make some brief presentations, and then we'll have some question and answer. And during that time, we'd like to hear from you how licensure is working in your life and career. And the feedback will be directly going into reviews of rules, which the board is undergoing now and undergoes regularly, and in our sunset application, which we're up for sunset in 2017. We just found out that the architects are actually up for sunset in a couple of years, and they're already starting to prepare for the criteria that DORA reviews the need for regulation. So we can also discuss that. So it will be a very interactive session, we think, for at least half of the session, and we look forward to your comments. So with that, I will introduce Dean to start us off.
Sure. I'm going to be fairly brief because, as Craig said, I'd like to keep this interactive, so I just want to mention a few things. I'm going to talk a little bit about the need for licensure and the relationship to health, safety, and welfare. So before I start, just want to get a sense for everybody in the audience. How many are landscape architects? Show of hands. Or training to be landscape architects? Okay. Landscape contractors? Anybody? Other professionals? Engineers? No? Okay. Yeah, I know you two guys. So just first want to talk a little bit about the need for licensure for landscape architects. And, the primary reason to have a licensure law is to protect the health, safety, and welfare of the general public. And that's really DORA's mission is consumer protection, mission number one. public protection through effective licensure and enforcement. I'll talk a little bit about the definition of the practice of landscape architecture and how improper design by unlicensed professionals can cause harm. The other reason to really have licensure is to level the playing field with other professions. Before we were licensed, I saw a lot of RFPs that would come out that said it had to be done by a licensed professional. So an example would be a trail project. We do lots of trail projects. There were many times where we couldn't be the prime. It had to be a civil engineer or a landscape surveyor or an architect. They didn't really care as long as it was a licensed professional. So that's something that sometimes gets overlooked, but the fact that we're now licensed, the same as these other professions, it allows us to go after more work. So what does it mean to be licensed? How do you get licensed? Angie will talk a little bit more about the specific process, but basically it's a combination of education, training, and then testing. So once you're licensed, does that mean that you're an excellent landscape architect? It actually doesn't. It just means that you've met the minimal competency standards to enter into the profession. So in terms of licensure in Colorado, the Colorado Revised Statutes, which is essentially the law, that became effective July 1st, 2007. And I don't want to bore you too much, but I just want to read a little bit about the definition of our practice. It's the application of landscape architectural higher education training and experience, as well as mathematical, physical, social science skills to consult, evaluate, plan, and design projects and improvements principally directed at the functional and aesthetic uses of the land. So that's the first part. Second part's collaboration with architects and engineers during the design of public infrastructure projects, such as roads, bridges, buildings, other structures, concerning the functional and aesthetic requirements of the area and project site. Or the last one is assistance in the preparation and administration of contract documents and offers related to site landscape improvements. So those are kind of the three basic definitions that are defined in the law. There are some exemptions. Basically, the other professionals I was talking about, architecture, engineering, and land surveying, that's exempted. Residential landscape design is exempt, consisting of design services for single and multifamily residential properties of 4 or fewer areas, not including common areas. Design of irrigation systems by professionals qualified by appropriate experience and certification, and then landscape installation and construction services. So including but not limited to all contracting services not within the scope of the practice of landscape architecture. So then the other document, and so that's the law, the Colorado Revised Statutes. There's also bylaws, rules, and regulations. Those further define the practice of landscape architecture as the core areas of knowledge generally identified by the landscape architecture body of knowledge. That was a study that was done by ASLA, CLARB, and ASLA several years ago. So that has a little bit more specific information about our practice. It also includes the core areas of knowledge that are tested on the LARE, which briefly are project and construction administration, inventory analysis and program development, site design, design and construction documentation, grading, drainage, and stormwater management. And there's two more. Designs, plans, specs, contract administration for improvements to public and private property that influence the safety, security, and effective functioning of the built and natural environment, and also plan review services. And the final one is the practice of landscape architecture includes construction observation of site landscape improvements. So just some quick, interesting licensure facts. There are licensure laws currently in 48 states. District of Columbia and Vermont do not have licensure laws. Of the 48 states, 40 have practice acts and 8 have title acts. Title act says you can't use the title landscape architect. It's a little weaker than a practice act. Most practice acts, and our law says you can't use the title landscape architect and you can't practice landscape architecture. And Colorado, I think, Angie, this is right, has 755 licensed landscape architects currently?
Approximately.
Okay, approximately. So with that, I think you're next, Angie. Thank you.
Sure.
Great.
Thanks, Dean. So I'm going to talk a little bit about the licensure process. Since most of you who have been through it, you probably know a little bit about it. But so please feel free to ask some questions if you would like to, if I skip over something that you wanted to know about the licensure process. Many of you probably know that Colorado is a direct testing state in that in order to become licensed, you go through Clark to take your exams first, and then you come to Colorado to apply to become licensed. And so in order to apply, you fill out an application having already taken your examinations. You provide that verification to Colorado that you've taken your exams and passed them. You provide information about your experience, and depending on what your education is, you have to provide a certain number of years of experience. And the information in your application has to be complete at the time that you provide your application. So in some states you provide some information and the rest trickles in. We ask for a complete application all at once as you're sending it in. And so then what we do is we take a look at the experience and the verification, making sure everything matches up, and do we have your transcript, and making sure that it's all complete. And then the application comes up to me, and I get the chance to look at that information, and the board has delegated authority to me to determine whether that application meets the qualifications under the law as well as the board's rules to determine whether the person is minimally competent. That delegation is in a public policy, so if you want to take a look at what that means, you can take a look at that. It's Board Policy 40.6.5, and what it means is that if everything is pretty much straightforward in terms of education, experience, and examination, then they've delegated that authority to me to go ahead and license an individual. If the experience is substantial, if the education is an accredited degree, you've taken your examinations, we want to get you licensed as quickly as possible in this state and not hold it up. We're not here to provide a barrier to licensure. If there is any anomaly whatsoever in the application, say that there is, for example, the experience doesn't look like traditional experience. It looks like maybe someone is deficient in some area of experience. And you might be saying, well, now how does she know what kind of experience is required for a landscape architect? Because I'm not a landscape architect, nor am I an architect, engineer, or land surveyor. But I do have a bit of experience having worked with architects, engineers, and surveyors for almost 18 years. So I have seen that kind of experience and reviewed those applications for a long time. And having worked with this program since its inception, I've reviewed those applications a bit. So I have a bit of a sense. And having worked with the board for a little while, taking a look at what the definitions are in the various areas that they're looking for, have some idea of what they're looking for. So if it looks like anything is off kilter, for example, there are categories on the application that we ask the applicant to provide percentages of experience, and if it looks like you only have 2% of experience in the design category, and that's probably too weak for someone to be minimally competent. And that would be an application that I would send to the board to say, do you think that this person has enough experience to be qualified to become licensed? If a person had practiced without a license, prior to getting their license. That would be one that would be sent to the board if it looks like they've been practicing between the time that we required licensure, January 1st, 2008, to the present time. Another instance might be if they already had a license in another state and they got disciplined by that state. And that would go to the board for review, and I would not be the one who would give a license without prior review by the board. Another example would be, unfortunately, people do have run-ins with the law these days, felonies for DUI, drug convictions, that sort of thing, and those go to the board for review just to determine whether the person is qualified and that is not something that would impinge on their ability to practice. So I think that's about it as far as licensure. I want to just make a quick note about some of the handouts we have here because I know some people came in late. We brought quite a bit of pieces of information. It kind of relates a little bit to what Dean said about the LARE. There's some information from CLARB that we got just for this presentation today about the changes in the exam, the transition, how it's changing. There's a chart as well as the timing. And so some of you might be interested in that, not only for if you haven't taken the exam, but also people in your office who might be interested in those changes because it's some pretty major changes. There's also some information about having a CLARB record and just how CLARB can help you, and some little pocket cards about CLARB. And then there's also some information about DORA, the other services DORA has, as well as our division and who else we regulate. So, thank you. And I think Chrissy's going to talk about the enforcement process.
So keeping in line with DORA's mission of consumer protection, we have a complaint process. And I know we're here to talk about landscape architects, but keep in mind that we do license over 40 professions. And so as I'm speaking, you can think about, your doctor, your dentist, your veterinarian, as I'm going through this process, because you're welcome to file complaints with those different boards as well. What is a complaint? It's an allegation that a licensee has violated the laws set forth in that Professions Practice Act. So in saying that, we've had 19 complaints since the inception of the board. All of those have been in unlicensed practice. So even though a complaint is an allegation that a licensee has violated, we can also receive complaints against people who are not actually licensed. So they may be calling themselves a landscape architect or practicing landscape architecture. And so those are the complaints that we've seen thus far. The complaint marks the beginning of the disciplinary process. So what happens when we receive a complaint in our office? We review it, the staff reviews it, and make sure that we have jurisdiction. Just an example of a non-jurisdictional complaint would be like a fee dispute, because we don't typically review those types of issues. So we review for jurisdiction, and then we would send what we call our 30-day letter to the licensee or to the individual who the complaint is about. And we call it a 30-day letter because we give them 30 days to respond to the allegations in that complaint. That individual will respond in writing, and I also want to preface that when we receive complaints, we like to have those in writing as well. So they will send their response to the complaint in writing, and then we will take the complaint and the response to the board at a board meeting, and the board will review both sides of the story, the complaint and the response. They will compare against what the statutes and rules say, whatever the complaint allegations are. They'll make a decision whether or not there is actually a violation of the law or the rules. If there's not, they will dismiss the complaint, and we will advise both the complainant and the respondent of that action. If they they might see that, yeah, it looks like there might be some violation, but we're not quite sure. They don't have enough facts. We have an investigative process, an Office of Investigations, and the board will refer that complaint to the investigative office. An investigator would be assigned, and then they would investigate it, contacting the complainant, the respondent, maybe some other witnesses, some other parties. They will write a report of investigation and bring all of that information back to the board, and then the board can have a better picture of what has been happening there. And they will review that and determine, again, are there any violations? If there are violations, then they will refer possible disciplinary action. They might want to have a fine, maybe continuing education. There's different things that they can decide to do as far as disciplinary terms. We have, as part of the Office of Investigations, we have what we call our Expedited Settlement Process, or ESP. It's kind of, in a way, a mediation type thing. The board would refer the information to that office, and the settlement, I can't remember their exact title, but that individual would draft up what we call a stipulation, and that would be sent to the licensee. And that individual can agree to that or not. If they do agree, they would sign it, send it back, and then the board staff would finalize the processing of that and update our complaint database. If that person did not agree to those terms, they can counter offer back to the board, and then the board can review that and they can make a decision whether or not they want to accept that counter offer or not. So that's basically the... Am I leaving anything out? Yeah. So that's basically from step one all the way through the process, whether it's dismissed or if there's actual disciplinary action. So I think that's all I have to say. Yes.
Real quick, you mentioned that the complaints are then brought to the board, and I don't know if anybody's talking about the board. How often does the board...
No, we haven't gotten any about you yet.
Well, I'm not sure.
We didn't talk about that.
The board. How often does the board actually meet?
The board meets quarterly.
Okay.
Yeah. So let me just add one more thing to this complaint process. Should the individual, maybe they make a counteroffer to the board and the board does not accept that, they want to fight that, they can go to it through a hearing process through our administrative law judge. And so a judge would actually review the matter, and then they would hand down what's called an initial decision. That may or may not be in agreement with what the board has initially decided, but that is another way that the licensee can either agree to or not the rest of the process. So.
Good question?
Yes.
How do you handle a case where there's an anonymous complaint? Someone wants you to know about someone who's practicing without a license, but they refuse to go on record.
The board does have a policy about anonymous complaints. They can accept them. It's really up to their discretion whether or not they will accept an anonymous complaint. Anybody else have questions for me at this point?
But in any other circumstance, the complaint is not anonymous.
Correct.
That process.
That is correct. Yes.
All right, let's let Jamie wrap up the presentation, then there'll be plenty of time for questions. So.
There's some pressure there. I'm going to try and wrap up. So yeah, you've heard the folks up here and Angie talk about DORA's mission being consumer protection. The state LA board as a business and technical DORA board supports that mission. We're a 5-member board, 3-year registered landscape architects, myself, Jenny Starosky McCoy, and Dean Pearson. We have a contractor member, Tim Emick. We also have a public member, Philip Patterson, who's a planner with the city of Lafayette. We're all volunteers. We've applied to the governor's office and been appointed by the governor. We all have 3 to 4 year appointments. The next seat's available in 2013, so if you guys are interested, start planning now. We meet on a quarterly basis. We just had our last meeting in October. The 2012 schedule is January, April, and July 20th and October 19th, so we'd welcome your presence at a board meeting. So overview of the responsibilities. As any other board that's part of DORA, we conduct general board business in terms of officer elections and minute approvals and anything else that would go along with the day-to-day business of running a board, regulating a profession. Our primary function is to review those license applications that are passed up from DORA staff, from Angie. And as she said, most are related to evaluating or validating experience and references in terms of anticipating or trying to derive, does the applicant meet the minimum qualifications as set forth in the statute and our rules? We do rely heavily on the LA experience definitions in the application, and I think from day one, the board, I've sat on the board since 2008, we've been very consistent and fair in that application of looking at everybody's experience. So we've really tried hard to be consistent, and we have been. Results, as you'd expect, are approvals, denials, and tables for further review. We have denied some applications. We've got some facts up here. If we table an application for further review, we might ask for better references. Well, we don't actually do that, but we might ask for some additional information or clarification about anything on the application. We might ask for some representative examples of your work. And the board's mostly interested in, are you competent at minimum level? We've looked at tried to look at a lot of construction documents, especially as it relates to grading, drainage, and stormwater management. Really interested in that. And then if you do request an interview, we have interviewed applicants in the past, and if you do request an interview with the board, that's something that can happen during the process. That's normally a face-to-face discussion that talks about your experience, your knowledge, your ethics, and then the applicant would present, and then the board would ask questions. Other primary activities, rulemaking and board policies. You've heard that mentioned today. From time to time, rules might need to be modified or changed for various circumstances. We do that on a yearly basis and can do that at any time. We can't change the statute because that would require legislation, but the rules are something that can be changed by the board through the process that we have. Board policies also, they refer to administrative procedures, including expired licenses, verification of experience, and confidential letters of concern. Christy talked in depth about complaints and cases. I direct you to the sections of the statute, 1245, 112, 113, and 114 to understand those better. I think it was mentioned that the most common complaint that we've seen to date, I think in the fiscal year of 11, it seems like we've had 10 complaints, and I think most of those have reflected practicing without a license or holding yourself out as a landscape architect. Going into disciplinary actions available to the board, it could be license. We could deny license. We could revoke your license or suspend it. We can issue cease and desist orders. So this is a lot of the stuff that's not so fun about what we do. And then, of course, we interact with our attorney, John Roberts. He's an assistant district attorney general who is available to the board to guide and advise all of our decision-making processes when it comes to disciplinary actions. Without him, I'm sure that some of us would be in jail by now. But that's been a real critical part of it too, especially when it comes to executive session. And then finally, we do participate with CLARB. We represent Region 4 with CLARB. We have a presence at the annual meeting, at the spring meeting, and then participate in teleconferences. I was just at the annual meeting, and if CLARB's a mystery to anyone, I can be honest when I say that CLARB was a mystery to me until I got a chance to attend that and really get a look behind the scenes and find out more about it. And as has been pointed out, Dean is a legend in the halls of CLARB apparently. So if you have any questions about that, you can follow up with him. Yeah, in a great way. So thanks for that. But newsletter and QA as well. Our newsletter needs to be updated. We know that, and the Q&A webpage. Christy and Angie constantly ask the board members, do we have any content to add? And I think the board, we just haven't added any. So that's kind of the board's fault. But overview of responsibilities and licenses, I'm probably over my time, right? I'd sum it up in 2 points. Maintain an active license at all costs, if you can, and avoid complaints. Just really quickly, as a licensee, you're an individual. The law says you're an individual person holding a license in accordance with Title 12, Article 45 CRS. That's the Colorado Revised Statute. You're also subject to the bylaws, rules, and policies of the State of Colorado Board of Landscape Architects. So if you're a licensee and you're engaging in the practice of landscape architecture, I'd encourage you to take a look at the statute and our bylaws, rules, and policies. I've got some hard copies here. They're available on the DORA website if you can find that page, and if you can find it, bookmark it, because you might not ever find it again. I have trouble finding it. But also, just as a licensee, your responsibility in terms of rules of conduct, I point out that section 3.0 and then the rules of landscape architecture practice 5.0 from our rules. The primary obligation, actually under 3.1, what it says directly from the rules of conduct is it says licensees shall hold paramount the safety, health, and welfare of the public in the performance of their professional duties. I think we all understand what that means. And then there's additional detail in 3.11 relating to that, as well as ethical conduct and responsibility for your seal. So you guys should be in charge of that in terms of the care, custody, and control and use of your seal. So I think that's basically what I have to present. If there's any questions.
Well, thank you, Jamie. As was mentioned here, CLARB has a big role in developing the definition of practice. As also was mentioned, they're in the process of issuing a new exam. And in order to get to that level, they went through a fairly extensive and rigorous process of defining what landscape architecture is and how it affects public health, safety, and welfare, the keys to any state regulation. And they just last month issued a white paper that was subject to quite a bit of research called Landscape Architecture and Public Welfare. And public welfare was always that health and safety are very easy, relatively easy to demonstrate in terms of the blood and guts and so on. But public welfare is sort of this nebulous term that is difficult to define. And I think they've done a very good job of defining in terms of environmental issues, community welfare, public process, sustainability, economic impacts, and so on. So I encourage you to go on the CLARB website and get that. I brought a couple copies here if anybody would like it. We can talk about it a little bit more.
And to Craig and Jamie's point, we have a direct link to the DORA Landscape Architecture website on our ASLA Colorado website. It's on the main page, so if you ever lose that link, come to our site and we'll send you over there. And to Craig's point, we're posting a copy of the executive summary of the CLARB white paper in the resources section, available to the general public in the ASLAcolorado.org website, and we're going to be linking to some of the other CLARB documents as well.
And I think
The green flyer up there is all about this.
And Neil, I think, wanted to say some things about advocacy at the chapter level, how the chapter interacts with the board, the ASLA chapter.
Well, the advocacy committee has been working on doing some outreach to local government agencies, county and municipal agencies, because we did a brief survey of some of the larger municipalities and found that many were not what we consider to be compliant with the state law. And there's also varying degrees of compliance, and there's many who frankly aren't even aware that there is a state law for landscape architects to practice. So we've developed this advocacy package, which is the green folders here, and then there's some brochures as well, which are to educate local agencies about what we do and why they should comply with the state law in terms of enforcing the state Practice Act. And so now we're kind of encouraging people, if you know that your community is not enforcing the state act, we would encourage you, first of all, to try to inform them about it, and we would like to back you up on that to some degree. We've got all the advocacy materials. They're also available on the website for download, but we've got hard copies we can mail out to anyone who can identify somebody that's receptive, or a local agency that's receptive to that, or even would like to push for it more in your community, because it is sort of about, it's not only about protecting health, safety, and welfare, but creating work for our organization and our members.
So we've had licensure for nearly 4 years now. How's it going? We'd like to hear from you guys. Questions or thoughts?
You explained very well how you police our side of the fence. I'm curious about the other side of the fence. Recent example is I saw a local town advertise for a Main Street project, and I asked, how come you didn't advertise this to landscape architects? And she said to me, you're not qualified. It only goes to civil engineers. We're only qualified to, in so many words, name the circles. It's a municipality. How do we educate them and get them on board?
Well, that's what we're trying to address with outreach from ASLA, and there's really not a lot you can do other than try to educate and inform and encourage, because I don't think there's any real enforcement mechanism for local government agencies. It is a legal requirement, but some of them, frankly, are just likely not to do it. They've got their ways of doing things, and they don't really want to change it. Just along those lines, I know we've kind of identified about 3 basic areas where local agencies should comply or recognize landscape architecture, and one is, of course, stamping the landscape plans, which it seems, if it's not residential, it should be a landscape architect involved, or at least supervising the work. The other would be site design, which a lot of municipalities are only allowing engineers to stamp those plans still, which is sort of what you're saying, I think. Whereas the state law now is basically saying that, no, we can do that as well. It's in the definition that's, on the board rules that we do site design. And the third area would be the actual works that are done by the government agencies. And if it involves the practice of landscape architecture, they should have a landscape architect involved in that process.
Well, this particular municipality complied with having a landscape architect stamp it, but they didn't allow an LA firm to be the lead. So they advertise only to civil engineers, who then has their landscape architect stamp the plan so they comply, but we don't get invited to the front door.
Yeah, I agree with Neil that a lot of that's public education of the staff at the municipalities and so on. And a good mechanism for that is the Colorado Municipal League, the CML, which just about every municipality in the state is a member of. And Neil did a great job this year getting an article in their newsletter about what landscape architects do. I mean, it's as basic as that. Some of the smaller communities especially don't really understand what landscape architects do. And if they did, then perhaps they'd have them leading these types of projects.
Thank you.
Can the board entertain a restraint of trade complaint?
If I might step in here. This is a discussion that we've had with ASLA for a couple of years now, and this is not something that is unusual for a newly regulated profession to run into this. And it's just going to take time and education on the part of the industry to work with local municipalities and educate and push this along. And it's something that's a grassroots effort that needs to happen, and each professional really needs to work with their local government and educate them and help them understand where the parameters are of this law. The board has done some outreach and effort and will continue to do that. A letter went out, I think within the first year of the board going into place, from the program director to all building officials, informing them of the law. And we have done outreach when there has been an opportunity, and we've gotten in front of building officials. We've talked about landscape architecture and the requirement for licensure and these sorts of things. So we'll do our job on that end. We had an opportunity, I think, when was it? Last spring, to talk about this. We were in front of building officials. There's the possibility we may do a handbook for building officials on the landscape architecture side. I'm just updating the one on the architects, engineers, surveyor side, and I'd like to do one parallel for landscape architects. That might have an impact to educate them from the state level, but it's just going to take time. It's just, we're in it's the growing pains.
Sure, no, that's understood. But I guess would the answer be no then, that a complaint is not an appropriate way to bring that issue in front of the board?
It's probably, you can always submit a complaint, but the problem is it's not going to go very far for the board to try and take punitive action against local jurisdictions.
But there
in my
could be a
experience.
notification to
Pardon
that. At least there would be potentially a notification to the entity, to the government entity or whomever, that a complaint had been filed.
And the board could
Maybe that's enough.
try and work with the entity, but the bottom line is it doesn't work very well for the state to come down on a local entity and tell them how to do their business. It isn't received very well.
Yeah, that kind of gets in the family business, doesn't it?
It's true.
I understood. Thank you.
Continuing education, is that on the horizon?
At the national level, through ASLA and CLAR, both support continuing education. ASLA is an advocate, CLARB is more of a supporter and a clearinghouse and a developer of what the parameters of continuing education are. At the state level, continuing education has evolved into a concept that is referred to as continuing competency, and the way it's interpreted in a regulatory statute, such as the landscape architecture statute, might end up being something that we don't want to get into right now. The architects went through this a few years ago, where they amended the statute to address continuing education, because AIA actually requires continuing education nationally to keep your license. So to get it into state law, it evolved into, again, continuing competency, and I'm not sure the specifics of it, but insurance companies said that by establishing continuing competency, you're basically uninsurable. And so they went back through the process of amending the legislation to come up with their own continuing education requirement, and that's what they have now. So we've been advised not to pursue continuing education at this time until state regulations are more favorable to education and not competency. So I don't know the details, and I don't know if you guys can weigh in on that at all, but that's where we are right now. We're not pushing it. We'll be up for sunset in 2017. And in the meantime, there's an ASLA conference, a national conference, which will focus a lot of attention on Colorado in 2014. So I think between now and then, we need to have this dialogue as to whether continuing education is necessary, whether it's desirable, and how it relates to current state laws that govern continuing education. Maybe looking at how the architects are doing. The engineers don't have a requirement. It's kind of open-ended at this point, but there's no ongoing advocacy right now.
So, Craig, you were talking about the through statute, through amending the statute. Is there a possibility to address continuing education through a rulemaking process?
I don't believe so. I believe that has to be amended in statute. It has to be a legislative act.
It's very sneaky of you, though.
The board,
Just wondering.
the board doesn't have the authority to institute continuing education through its law currently.
Through a rule. Yeah.
Right. It's not in the law, so therefore they can't do it through rule. So the board has to have authority in its law to do something by rule.
I think nationally, of the 48 states that have licensure laws, about 30 have continuing education requirements.
Sure gets people out to the national conference, too.
It's not well,
And it would be interesting to compare with other professions, physicians, dentists, accountants, other regulated professions. It would seem that a majority of those would have continuing education requirements. At least many of the professionals in those areas that I know of speak of it. But I'm sure that varies from state to state, too.
In Colorado, I'm not sure to what extent that all comes back to the concept of competency and exactly what the legal distinction is between that and education. I think competency in itself infers some higher level of responsibility or in the outcomes. Is the uninsurable part.
Oh yeah, it's a vexing problem.
The concept is that you can demonstrate in a clear way that the professional has increased their competency, that it's not just that they've gone to CE offerings and can say that they went to them and prove that they paid checks and did that.
Which ones did they go to?
Yeah, and had seat time or didn't have seat time and were on ski slopes or whatever. But that they, in fact, increased their knowledge, skills, and abilities in some demonstrative way. And that they fulfilled or changed their deficiencies in their practice in some way, and what were those deficiencies and how did those change. And that's entirely different than just taking CE. And it's far more complex, it's far more, it takes a lot more time to define all of that, and so it's a lot more involved. So I guess I would encourage you, as you embark on those debates and discussions, that if you are wanting to go down the path of CE at all, that you keep in mind the thought of what is the value? What is the real value for getting CE? Does it, in any of those professions, not just who has it and who does it and how much, but is there really a value in the profession?
Yeah, I think it's assuming that all professions change with technology, with time, with new circumstances, and the recognition that all professions need to, even to be able to practice at that minimally competent level, need to be brought up to date. I mean, essentially. I mean, that's accountants can still perform their accounting functions, but if there are new formats that are required for them to be more effective, I would assume that would be something that would be in a continuing ed program. They could still be minimally competent, but they may not be as up to date and as effective to their client as they might be otherwise. And I think that to me is more of what might be the standard of continuing education in other professions.
The problem was that there is absolutely no linkage between CE and a more or less competent professional. There's no evidence, there's no studies, proof that there is any linkage.
And Mark, just to comment on what you said, to me it sounds like you're raising the bar of minimum competency in your commentary.
No, I guess I was suggesting that minimum competency could still be possible without incorporating some of those new techniques or technology, but that you could enhance your competency with some of these new techniques or new technologies or new awareness.
I think there's a lot of firms and landscape architects that are doing that without CEs in place. Or without CUs in place, so they should.
And you hit on the issue that was the bugaboo for the architects.
The problem is, how do you measure?
No, and I understand. I understand
the
the
bar,
I
and then
understand the
everybody's got to
difficulties.
ratchet up to the minimum competency. So,
I think there was
On that, I have a question on those types of documents. What do you call the builder document or
Builder's manual.
the builder's manuals? Is there any discussion in those about insurance requirements?
No, there is not on the AES one, mainly because there's no requirement for insurance for engineers or surveyors and for architects. The law only says that if you have insurance, it has to be within certain provisions.
Well, the only reason I bring it up is that as I'm an insurance broker, as many people know, but we review contracts all the time for our clients, and the municipal contracts that we see are almost 98% written on behalf of construction contractor. So the insurance policies for construction-related businesses are very different. They're written very different than a typical insurance policy that, say, a landscape architect or an architect or an engineer's office would have. And we talked a little bit about earlier about the requirements for construction observation, some of those types of things, what happens if you stamp a drawing but there's no construction observation included in the scope. I mean, we see some of those things where in the contract stages where you're negotiating those contracts with your client, those are where those areas can be included in the contract, and that's where I think, as Greg mentioned, it can be enforced or at least educated to your customer that says, hey, by law, you guys have to allow this construction observation as part of hiring a licensed landscape architect. But because the contracts are written for a contractor, there's no opportunity in there for the landscape architect to be able to put that wording in there. So I guess my question is that it's just very frustrating, and probably for a lot of the professionals that are here, when they see these contracts, they're written for contractors and not for consultants. And the insurance requirements are very different. We battle with the municipalities all the time, saying they're asking for insurance requirements for this type of an issue that has nothing to do with the landscape architecture firm. It would be something that would be very specific to, say, the actual builder or contractor. So I'm not sure exactly what point I'm trying to make. I just think it's difficult with these contracts that these guys are seeing. And that's one thing too, is that when you get these contracts, that's your opportunity to go back and really work with your client and say, hey, this doesn't fit, and you need to be able to be flexible with me to realize that we're not the contractor, we're just the consultant.
Do the AIA or ASLA standard forms remedy that issue?
They don't. The ASLA, well, they do in some respects, but there's still, even the AIA form is still, there's lots of stuff related to the contractor in the AIA forms. The ASLA form, it does get better, but when it gets like construction observation and how it coordinates with the law in each state, there's no mention of that in there, I don't believe. But you get a contract with a city or a public entity, they're not going to use the ASLA contract. They're going to use their own contract and say, sorry, you don't have a choice, you got to sign this, or we're going to go find somebody else that will. So that's where, in your terms, you're saying your advocacy and you're saying the landscape architect needs to step up and be forceful in that and say, no, you guys, by law, you need to do this, and here's where it states in the statute that you have to allow these things to occur. But mostly, as we all know, you guys are scrambling to get work, and you're ready to sign it and say, I need the money, and I'm willing to deal with it later on if something happens.
Well, and I don't want to belabor this, and we could talk about this afterwards, but I don't see where it says in the law that they have to allow you to observe construction. It seems to me that that's a negotiation point in the contract.
It's just one definition of the practice. It doesn't say that they're required to do that.
Right. So I just want to make sure that we're not on two different pages here.
Also include,
It's a negotiating point. It's not required.
Right. It says that the landscape architect has to be responsible charge.
But I guess my point is there are all kinds of things that happen in construction. This is something that architects face. This is something that engineers face, that they don't necessarily get to observe construction, and it's something that gets negotiated as part of their contract. and they may or may not observe the construction. And yes, they have to be in responsible charge, but the observation of the construction is part of the negotiation process.
I believe AIA
Do you understand what I'm
changed their
saying?
language away from in charge of observation so as to avoid that particular conflict.
So I'm
I don't
saying
know if
you have
that's
the
what
same problem as engineers and architects have. So I guess.
So how do you ensure yourself and your skill as a landscape architect?
You write the SWIP form, and then you have to be out there at least once a week or after every major rain event. And if you want to know about
It's
that,
part of, again, it's part of the negotiation process, and I'm just saying that that's something that your colleagues in those professions face too, and that's probably something that you may want to be talking to your colleagues in those professions. ACEC, I know, has had plenty of seminars on this same subject, and AIA probably has too, that they face these issues. And I think you're right, the AIA contracts have addressed these sorts of things to try to deal with it, but you're not alone in that. But there's nothing that requires the owner to allow you to be out there a certain period of time.
One of the things
in the statute.
One of the things we were advised when developing the legislation was to establish the definition of practice to be somewhat, I guess, purposely vague, in that landscape architects practice landscape architecture, and keep a lot of the detail out of it. So we do planning, we do design, we do construction observation. These are what landscape architects do. It doesn't say that we have to do that, but it does establish some broad parameters that are further interpreted through the rules and regulations and can be modified through updates to the legislation. The purpose of that is that the profession does change over time, and you don't want to really be locked into things that you may not be doing 10 years from now or so on. And it may just not belong in a legislation that the state legislature is voting on. And the architects and the engineers and other professional regulations are kind of written the same way, so you can follow a template. So that said, that definition of practice is important. It does say landscape architects practice landscape architecture, and then that body of knowledge that we bring to the table is further defined by Clark through testing and so on. And the architects and the engineers also. And in each one of these statutes, there's exclusions that allows them to, I shouldn't say practice the other professions, but they're not excluded from, or there's, help me here, the exclusion allows them to,
Well, there's overlap.
Yeah.
Engineers do grading plans and we do grading plans. I'd argue we do them better, but we both do grading plans. In my mind, they do grading plans for roads and things like that. We do them for parks and trails and things like that. So, I've seen engineers stamp grading plans for parks. I don't think that's right, but I think that comes back to the education. We have to educate our clients. We have to force the issue. We have to kind of get ourselves in there and show them we can do a better job. And not just stamp planting plans.
Other thoughts or questions? There is one thing I thought I'd bring up too that Jamie reminded me of before the meeting is that there's been a lot of discussion of the use of RLA after your name, or architects have RA in some places, or AIA, and so on. And at the national level, ASLA just voted to use the term PLA as something that's up after your name instead of RLA. And RLA has never really been officially adopted, I think, in statute here, maybe in the rules and regulations, though it's not. So I guess I'd just be interested to hear impressions of that. And to me, it seems a little weird. I've never used that acronym.
Well, maybe I could give you just a little background. I could give you a little background on it since, as trustee, I was asked to vote on this at our recent meeting in San Diego. Some states have what's termed as registration, and some states have licensure. Using RLA in a state that has licensure is not a correct terminology. I think ASLA was trying to develop a policy that would be uniform across all of the jurisdictions. And professional landscape architect, PLA, kind of on the model of professional engineer, PE, was the most universal. I agree, it is a bit odd sounding, but that was the reason why that was advanced.
Any other thoughts, questions?
One more. This is, I'm sure you've gone through this many, many times. Yellow pages. You pick up any book, Yellow Pages, and 9 out of 10 landscape architects are not landscape architects. What can you do about it? Nothing.
Well, I think that's where the complaints are coming into DORA, where there is a formal complaint about somebody's not practicing.
To each individual person listed in the Yellow Page that isn't a landscape architect, I can make an individual complaint?
If they're representing themselves as a landscape architect, yes. And in fact, when I was in New York,
we don't love them, but yeah, we can.
We've seen photocopied pages out of the Yellow Pages.
Pardon me?
We've seen photocopied, pages out of the Yellow Pages as part of complaints.
Yeah,
Those facts.
Jack Frost Grading and Landscape Architectural Services, or Snowplow and Landscape Architectural Services.
Don't those go together?
Somebody will chase them all down some days.
Would that be considered a violation of the act, I guess, if they are advertised?
If they're not registered landscape.
If they're representing landscape architect themselves as a landscape architect or offering landscape architectural services, yes.
Yellow
Maybe
Book,
to
I
have,
think.
I guess, at least someone on staff, if not the principal, right?
Right.
One of the things that makes it more complicated than that is that there's how many people publish Yellow Pages now. Like 25 different Yellow Pages that come. But one of the things that, from a regulatory standpoint, you guys might see if you can at least bluff your way through it, and that is to get to the publisher so that when they sell that ad, they have the people that sign up for it sign the disclaimer that says that they actually can, in fact, do that. Because what you're going to have is somebody who says, well, the deck salesman came by and he told me I got this free listing here, and all I got to do is say I'm a landscape architect, and I can get another listing. And so I say, sure, I don't know any better. And if you come after me and I don't know anything about the licensing rules or anything, and I claim ignorance, then I kind of get the first pass for free. Because I can say that the aggressive salesman made a mistake. And if you can get to the salespeople, just like I would doubt that they try to sell me a listing under the physician's listing, just because I, say I got a PhD or something, I want to play like I'm a doctor. I'll bet that they do a little bit of sort of pre-qualification to make sure somebody's really a physician. And if you can throw it back on the publishers to at least try to hold them a little bit accountable for it. And that's one way to try to deal with it. But some of it's just, like Craig says, growing pains as people get used to it.
Those are some of the things that the government affairs and advocacy group for that chapter talk about, and those are the action items that we've been working on for the past several years. And we'd invite anybody that's interested in participating in that. Neil's the head of the committee and is always looking for people that are interested in helping out. So this advocacy package is a great accomplishment of the committee in the last year. We're going to all the local governments as a talking point for that advocacy. So,
and let me make one clarification, Neil. It has to be somebody in responsible charge.
That's
A
what.
licensee in responsible charge.
So
at a
you can't
minimum.
just be farming out, getting it stamped by landscape architect.
Right, but it doesn't have to be a principal or an employee either.
Oh, really?
Right. So I just wanted to clarify that.
If there's no other questions, I'd like to thank our panel here today, and thank you all for coming.